This is AfricanPod Business Forum, the part 2 of the conversation about the risk companies face when they invest in other countries. My guest is Dr. Sam Latrell, a partner in the law firm Clifford Chance in the Australian office in Perth. It's a thoughtful, illuminating conversation for this second part. What is the level of risk companies face?
I think the level of sovereign risk that a company faces when it invests in a foreign country, there will always be a variation depending on the country concerned. So each country has its own sovereign risk profile that will be a reflection of the particular legal and political and economic conditions in that country. There are therefore different factors that come to bear in different jurisdictions. What can be said though is that the poorer countries, where the rule of law is not as strong, tend to pose risks for foreign investors that wealthier countries, where the rule of law is stronger, don't necessarily pose the same risks. The principal risk used to be that the foreign investors' assets would be directly expropriated. So the government would nationalise the assets. And by nationalise or directly expropriate, I mean the government would pass some measure that made the investors' title to those assets void or declared those assets to be state property. That happened in the 20th century, often in context of Marxist revolutions and independence movements where collective ownership was a political imperative. And those events did lead to claims against the relevant governments under contracts and in some cases investment treaties. Those nationalisation events were very, very significant in forging the system of international investment law that we have today. But what happened is that most governments now understand, as a result of those experiences or observing those experiences, that direct expropriation is a high risk political move.
It's become a higher risk.
That's right. And the system of investment treaties has given investors access to forums where they can enforce claims for direct expropriation and other treaty breaches. So governments don't tend to do that much anymore. So direct expropriation used to be the main risk that foreign investors faced, and it's not the case anymore. The risk that foreign investors tend to face now is that there will either be changes to the regulations that govern or apply to their investment that make their investment either less profitable or just non-viable. Those changes often come in waves, so in a creeping fashion rather than a staccato direct fashion, and they are sometimes hard to spot. Those forms of measures, composite measures or creeping measures, are far more common today than the direct form of expropriation and other breaches that we saw in the 20th century. So creeping measures that are disabling a business or disabling its productivity or preventing its long-term sustainability, that's the most common form of measure that we see, and that is the type of government activity that triggers claims today.
And it brings to the fore the fact that, what preventative steps can be taken by companies that invest abroad?
Well, I think it's the nature of a creeping or composite violation, a creeping expropriation, to use that as an example. The nature of it makes it difficult to spot because it's happening slowly over often a fairly long duration, and investors are sometimes aware that something is going on, that there is some targeting of their investment or the political tide has turned against them, but they don't necessarily understand the significance of events or measures when they occur. So each investor needs to understand the life cycle of their own investment very well. For those investors who have businesses that depend on permits or licenses, it'll often be a case of understanding when those licenses are going to come up for renewal, what the timeline is for each license, how the timelines of different licenses interact. For example, if you've got a mining license that runs for 20 years, but you've got a blasting license that only runs for 2 years, and you need the blasting license to mine under the mining license, then your renewal intervals for the blasting license are actually pressure points in terms of the economic value and utility of your rights under the mining license. So you want to understand the way different permits and approvals interact, because it's only once you've got that clear you can see where the real risk windows are in the longer term. You can also, with some, it's art, it's not science, but you can look in, if you're investing in a democratic polity, you can look at the probable election cycles and overlay that political timeline on top of the licensing sequence that I've just described, because it is often the case that elections produce radically different policies with respect to foreign investors and foreign investment. And if there's a change in government coming, or a change in government has occurred, the pressure points that might naturally exist in, for example, your licensing sequence, they might be used by the government to achieve a political objective that they have set in the context of an election. Now, that's making it all sound preconceived and planned and orchestrated, and I'm not saying governments behave like that necessarily. Many governments are very, very good with foreign investors and deliberately seek to encourage and protect and promote foreign investors. But in countries where the political tide has turned against foreign investors, those risk windows do start to matter. So you've got to understand what it is about your investment that puts you subject to the government, discretion, for example, in applicable laws and regulations. You've got to understand where those discretions or areas of legal risk, permit renewal, for example, where they arise, and you've got to use your best judgment to predict when in the political cycle those risks will become most acute.
I guess that's why you described it as not being in science, but more as an art.
That's right.
Yeah. So I'm trying to be careful not to go into an area that you rather not talk about. For example, anything to do with the politics of businesses and the countries they invest in. But I'm just wondering if it is your thinking or realization that sometimes it's got to do with the fact that the host countries and the investors don't see eye to eye, where they agree that this is a win-win for both of them. How can businesses make sure they play such that both parties realize this is win-win?
Yeah, I think that is a very good question, and I think it goes to an important issue. The investor-state relations are dynamic. In a long-term investment, things change on both sides. That is especially the case where, for example, the natural resources sector, the investor is exploiting a commodity that has a traded price, and it goes up and down. Now, if the investor has the rights to exploit the commodity over a 20-year period and mine the metal or the mineral, or extract oil or gas, the public know how much money the investor is making, or they can guess. If the price of the commodity is very high, the public will know the investor's margin is large, profits are big, and that makes the investor, I think, an easy target in political terms. One of the things we see is that investors will sometimes be perhaps reluctant to acknowledge that, not perhaps aware of how they are a target and how the public in the host state perceive them. And sometimes investors should, I think, be more willing to offer concessions or additional benefits to the host state, rather than stand hard and fast on the written word of the contract they signed or the agreement they entered into with the host state. So I think there is a time and a place for flexibility. in investor-state relations.
That's got to do with what they call enlightened self-interest?
I think it is enlightened self-interest. I think that's a good way of putting it. I think it is. I think it's good business practice to be responsible and to be reactive, including to the social and political and environmental and cultural issues that you face when you are a guest investing in a foreign land. But it is at the end of it, from a lawyer's perspective, it's a good risk management strategy, because you are doing what you can with what you have to manage a risk that is in large part outside your control.
Which is to say, legally speaking, it is part of risk control to say we'd rather choose not to go to the court, we'd rather settle than go to court.
That's right, and a lot of what we're talking about here is these are strategies that can be adopted or implemented to avoid a dispute. This is dispute avoidance. So it may be that the investor, knowing that it is the subject of a lot of adverse attention in the host state, it may be that the investor makes a conscious decision to get out in front of that and engage proactively with the host government to find a way to rebalance the agreement that the investor has. Now, that's one way of doing it. There's other ways, other contributions, other strategies the investor can pursue, but they're all really risk avoidance strategies. If a dispute has arisen and there are legal proceedings underway between the investor and the host state, then there will be normally windows in which the dispute can be resolved amicably, and any sensible business will always give full and frank consideration to a reasonable settlement offer in a litigation or arbitration context, because every party that's involved in legal proceedings has risk. It doesn't matter if they've got the best case in the world. They've got risk because it's a human affair.
I'm thinking back to the Investing in Africa forum that took place recently, and you had your chance to speak to some of the investors there. I was struck by just how factual and in your face your advice to them was, in terms of the fact that, hey guys, you better watch out. If they perceive you as some sort of honeypot, they'll come for you.
I think that's true of some jurisdictions, and some of the jurisdictions we were discussing, I have first-hand experience of how that can happen in those countries. It's certainly not the case that all governments take that view, but it is the case that some governments do and are well known for it. The problem becomes that those governments they burn bridges with foreign investors that they do need. Every country needs foreign investment. Without foreign investment, economies stagnate, and when economies stagnate, job creation falls away and tax bases erode, and there is not a budget to do the things good governments need to do and want to do for their people, like educate children and run hospitals and build roads. So foreign investment's essential. And governments that burn bridges with foreign investors do themselves and their people a disservice in the long term. But there is always a need for balance. And to go back to your point before, investors need to know that the relationship that they are entering into with their host government is dynamic. If it's a long-term investment, it will be a dynamic undertaking and a relationship like any other that they need to manage.
Can't help but mention the fact that, when we were preparing for this interview, I called you at a point and you said, yeah, you're preparing for a trial. And whereas you obviously didn't say anything beyond that, I could just sense in your voice how much of a pressure it is to prepare for these dramatic scenes that often take place in the courtrooms. How really is the preparations like just before you go to court and when you do go to court?
It's very involved. So to do cross-examination, for example, at a large hearing or trial, you need to prepare in a way that you don't need to for other forms of legal practice. Cross-examination is about immersion. You need to basically become as familiar with events as the witness you're asking about those events, and you will never be as familiar with them as that witness, because they were there and you weren't. So it's almost an impossible task you set for yourself, but you have to go and get it done. And it's very, I think it's very intense. You need to immerse yourself completely and live in that world and understand the story of the case.
How intense is it?
It's fairly intense, and it takes a while to get over. It takes me about a week to stop asking the questions in my head as I sleep. But it's fascinating, and it's incredibly exciting. Trial or hearings are, as I said before, they're a human affair. They can be very dramatic. There's often a lot at stake in the cases I do. So, yes, it's a big crescendo after often a very long paper-driven legal process. Cross-examination is as close as legal practice gets to open heart surgery. It's the only context in which the patient can die on the table. And that's what makes it different to other jobs lawyers do.
So why do you like this job?
I like it because it's stimulating, intellectually stimulating. It's honourable. I'm proud of the work that I do and the way I do it with my team. And it's important. I think it's really important what firms like Clifford Chance do as part of their participation in the global order.
What is really the good you would say Clifford Chance and you do for not just the Perth community, but as you kind of suggested earlier, the wider global community?
The rule of law. Major law firms are very, very important contributors to the maintenance and progression of the international rule of law. And in my view, nothing is more important than the rule of law, because if you don't have the rule of law, you can't make rules that you need to make to provide for a stable and prosperous and sustainable future for everyone.
What would you tell businesses as to how seriously they should take this aspect of their practice, the need to keep an eye on the legal ramifications of the decisions they make?
Well, I think investment protection as a business discipline is essential. Any business that is, raising money on a stock exchange from members of the public, with the intention of spending it on an investment in a foreign country, has a legal obligation to embark upon a sound due diligence and investment protection program in order to responsibly spend the money they've raised. Investment protection, I think, is better understood now than it was even 5 years ago. But I still think businesses need to be conscious that there is a world of investment protection strategy that some lawyers know very well, and businesses generally don't know as well. So I think they need to be aware of the services that are available and the way law firms like Clifford Chance can help them plan and execute investment protection strategies that will ensure that the business they build in the foreign country will be sustainable and durable in the long term.
Dr. Sam Luttrell, it's a pleasure talking to you.
Thank you very much, Philip.